June 28th edition of PFTPM. It's a Friday, not leading into a holiday weekend. That's kind of next week. The 4th lands on Thursday, so it really isn't that 4 or 5 day vibe where everything resets and we come out on the other end feeling very different. The NFL could use a hard reset after what happened yesterday in federal court in California, the Sunday ticket verdict. Now, we talked about it yesterday when the verdict first was entered, and there was some confusion early on about what the verdict actually is. We now know, and the league has confirmed, $4.6 billion for the class of residential Sunday ticket customers from June of 2011 through February of 2023. That's 12 seasons. 2.4 million residential customers, $4.6 billion for them, and another $960 million on top of that. 96 million. I keep getting this wrong. 96 million, not 960. Slight difference. 96 million for the commercial establishments that were, according to the allegations and as accepted by the jury, overcharged through antitrust violations for the Sunday ticket package. So that is $4.696 billion. When that gets trebled, and let me just do it one more time to make sure my math is accurate, because sometimes it is and sometimes it ain't. 4.696 times 3 is 14.088 billion. See, under most civil legal standards, when you have somebody who deliberately did something wrong, something that intentionally violated someone else's rights, part of the recovery is potentially punitive damages. In the antitrust field, there is no requirement to establish punitive damages, to go over and above the violation. The violation in and of itself requires punishment, and the punishment is whatever the verdict is that's rendered by the jury gets multiplied by 3. That's how 4.696 becomes 14.088. That's the number. And I've seen 4.7 all over the place. People just either don't realize or I feel like I don't want to spend a whole lot of time on this because I think the coverage or lack thereof speaks for itself. But man, there's a lot of media outlets that aren't really paying attention to this. And it's either they just don't understand how significant it is, or they've decided we're going to look the other way on this. We're going to do the NFL a solid here, either because they have a relationship with the NFL or they want to have a relationship with the NFL. The NFL is really big and really powerful, and I think a lot of people are exercising editorial discretion to not make a big deal about this. I'm not one of those people. And hey, it's one of the benefits of the deal that we did with NBC 15 years ago, Monday, July 1. That's the anniversary. The promise that was made to me by Rick Cordella, who's now the head of NBC Sports. He was the head of NBCSports.com at the time. I get final say over anything and everything that I write. And look, there are some restraints that apply here because this really isn't my platform, but still, it's an extension of what we write about. And I'm going to cover this thing. It needs to be covered. If it makes people at 345 Park Avenue uncomfortable, I got some free advice. Don't violate the federal antitrust laws, and then we won't have any reason to talk about things that you might not want us to talk about. So where does this go from here? Spinning it forward, things we didn't know or at least didn't get into yesterday. July 31 is the next key date. That's when the lawyers go back to court for the hearings on what they call post-trial motions. One hearing. I accidentally added an S at the end of the word hearing. I apologize. Hearing on post-trial motions. And the biggest one is the NFL's request for judgment as a matter of law under Rule 50 of the Federal Rules of Civil Procedure. The judge didn't rule on that request for judgment as a matter of law before the jury verdict. The judge said, I'll hold this until after. The judge could take it all away. The judge could say to the plaintiffs, hey, there's a defect in your case. You failed to introduce sufficient evidence on which a reasonable jury could base the verdict that they entered. Well, why would they enter the verdict then? Are you saying the jury isn't reasonable? No. The argument would be there's a technical list of requirements I was on Mad Dog yesterday, and I said it's kind of like and I may have said this here too. Hell, I don't remember. It's like when you get the Lego set and you've got the booklet and it shows you how it all goes together. Like there's a step-by-step thing to build what it is you're trying to build. If you leave out steps, you don't build the thing you're trying to build. And somebody may say, hey, that looks nice when it's done. Yeah, that looks nice, but it's not what it was supposed to be. So the jury, by virtue of the fact that they probably don't like what the NFL did here. And what the NFL did was very simple. They came into court and their witnesses all said in very self-serving fashion, we didn't have any conspiracy to rig the price of Sunday tickets so people would choose to not buy it and just watch whatever games were on their local CBS and Fox affiliates. And we didn't intend to do that. We didn't design to do that. There was no side deal with CBS or Fox. All of the stuff they said from the witness stand, there were plenty of documents that trickled in throughout the course of the trial that contradicted that. And so even if there was some potential flaw in the evidence that prevents all of the elements being proven, or at least to have enough evidence to support a jury verdict on that point, it all comes down to what the jury decides it wants to believe. If there is some flaw in the evidence that was presented that prevents that step-by-step instruction on what it takes to lead to a federal antitrust violation, that's what could cause the judge to say, I'm throwing the whole thing out. And the jury, and this is what happens. The jury is going to make its decisions based upon what it does or doesn't believe to be fair. The jurors aren't lawyers. And, you know, in a lot of jurisdictions, they don't even send the instructions back with the jury when it's time to deliberate. They're basically at the whims of whichever lawyer persuades them the most to go along with what the lawyer wants them to do. And I think by the time they got to the end of this case, the jury was far more inclined to accept what the plaintiff's lawyer had to say than what the defendant's lawyer had to say, which explains why the NFL lost and why the number was so big. But if there is a fatal flaw lurking somewhere in the case that was put on by the plaintiffs, the judge could still do what he threatened to do in open court a week and a half ago. And that made a lot of waves because it is unconventional for a judge to say in open court, I'm going to throw your case out. That's why it's still possible the judge will throw the case out. That would be something. NFL loses a verdict, $14.088 billion when you triple the 4.696, and now the judge pulls the plug and it's all gone. The magnitude of the verdict means that whoever loses coming out of Judge Gutierrez's courtroom is going to appeal as aggressively and extensively as possible because there's too much money attached to it now. It's guaranteed that whoever loses here is going to go to the next level, and that's what I'm going to talk about now, the first rung on the appellate ladder. The United States is divided into various circuits for appeals court purposes. California's in the Ninth Circuit. You have an automatic right to appeal. And I was explaining this to Mad Dog yesterday. There are, 15, 20 judges on the circuit, maybe more. I don't know exactly how many, but I do know this. When it's time for the case to be heard, you show up and you find out which 3 judges are going to handle the case. And it's roll of the dice, luck of the draw. And you might get 3 judges that like your case. You might get 3 judges that don't like your case. It might go 2-1 for you. It might go 2-1 for the other one. And that one judge, the third one, however they do the random process of picking the judges, that third judge, it could have been a different one and everything changes. That's how close these cases can be. After there's a ruling from the 3-judge panel, there would be an opportunity to seek a rehearing in front of the whole court. Then the next step would be to take the case to the U.S. Supreme Court. And the whole idea of a rehearing before the whole court, that doesn't happen very often, but I think it's one of the steps you're required to take. There's a lot of things when you're trying to preserve your ability to appeal issues in the court system. You've got to try, you've got to exhaust, you've got to do everything that's available. You have to check the boxes. And I think one of the boxes you have to check before you can file a petition for appeal with the U.S. Supreme Court, and they technically call it a writ of certiorari. I don't know what that means. I think I know how to spell it. I think I remember that much. But basically, you want the Supreme Court to take the case. Before you can even ask them to do it, you've got to appeal to the first level federal appeals court. You have an automatic right of appeal there. Then, if you lose, you file the motion for a rehearing before the full appellate court, all the judges of the appellate court. They don't have to do that. You have to ask for it, I believe, to preserve your right to then ask the Supreme Court, please take up the case. And it feels like it's destined for the Supreme Court. That doesn't mean the Supreme Court takes it up. 4 of the justices have to agree to take up the issue. If 4 take it up, 5 have to rule in favor. Sometimes the court will take up a case because they want to affirm the decision and create precedent that would make it clear coast to coast what the law is. And that's one of the things you try to sell the U.S. Supreme Court on when you're trying to get them to take your case. Hey, on this issue, there's a split among the various circuit courts of appeal. Half of them say this, half of them say that. You need to take this case up and you need to resolve this so we all know what the law is. We know what the rules are. That's one way you get in. Or they just think it's an egregious miscarriage of justice and they want to overturn it. That's where the Clarence Thomas Super Bowl ring potentially comes into play. That's where the reality that 6 of the 9 justices were appointed by Republican presidents and have a pro-business bias, whether they admit it or not. And it makes it more likely that the NFL will win. It's a lot to pin your hopes on. Because first you got to get in, and then you got to hope you'll win when you get in. But it's not as flimsy. It's not as remote. It's not the kind of long shot that maybe you would think it would be. They actually do have a chance to win this thing. They're going to be nervous. They're going to be anxious. There's going to be a lot of fretting and planning for how to come up with $14.088 billion plus all the other stuff. I wrote about this at PFT today. Interest, pre-judgment, post-judgment, attorney's fees. The number at the end of the day, if $14.088 billion stands, is going to be more than that. A lot more than that. Not billions more, but maybe closer to 15 billion than 14 billion by the time it's all said and done. So a lot of eggs in that basket, but the Supreme Court could ultimately provide relief for the NFL. And here's a rough timeline. July 31, that's when the judge is going to hold the hearing. Let's say the judge issues a 35-page written ruling on the post-trial motions before Halloween. That would give the losing side 30 days to file a notice of appeal to the Ninth Circuit. Then the Ninth Circuit gets it. They communicate everything. They ask for the record. They set a briefing schedule, and they let the case work its way through the appellate process. That usually takes about a year. So that gets us into late 2025. Then, if you take it to the Supreme Court, we're getting into 26 or 27 by the time it's all said and done. So there could be a lot more time that goes on before this is resolved. The end result could be a much greater final bottom line award because the interest is going to keep racking up as time goes by, or at the end of the day, the NFL could win the whole thing. We'll see how that plays out. And again, it's been around for 9 years. We're looking at maybe 3 years or so before this whole thing is resolved. Hi, it's Mike Florio. Thanks for watching PFT on YouTube. Hit subscribe for the latest news and analysis from Pro Football Talk.